All rise. Supreme Court of Guam is now in session. Honorable Chief Justice Robert J. Torres presiding.
Good afternoon, councils. You may be seated. Before I ask the clerk to call the case, I want to thank councils for accommodating the court schedule with the change to this afternoon because of the state funeral today. Will the clerk please call the case?
This is Supreme Court Case number CRA24-010. People of Guam Plaintiff Appellee versus Derek James Simmons, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Christine S. Tenorio, and appearing for Defendant Appellant is Attorney Christian Spatansky. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Spatansky reserves 5 minutes.
Mr. Spatansky, you may proceed.
Good afternoon, Your Honors. Mr. Chief Justice, and may it please the court, this case concerns 3 errors that undermine the fairness of Mr. Simmons' trial. First, the trial court erred in instructing the jury with language found in 9 GCA section 25.40. While correct in sufficiency review, this instruction improperly highlighted the complainant's testimony and risked confusing the jury about how to weigh the evidence. Second, the trial court erred in applying the wrong legal standard when evaluating Mr. Simmons' motion for a new trial on the basis of newly discovered evidence of juror dishonesty during voir dire. Finally, the trial court wrongly admitted hearsay evidence through a Guam police officer, allowing the government to introduce out-of-court statements that reinforce the complainant's allegation. We ask this court to reverse Mr. Simmons' convictions and remand for a new trial. First, the trial court erred in instructing the jury that the testimony of a victim need not be corroborated in prosecutions for criminal sexual conduct. Your Honors, I think it's important to first start my argument by viewing the jury instructions as a whole, as I do believe that is one of my colleagues' arguments. Several courts mentioned throughout both parties' briefs analyzed jury instructions within the context of the entire instructions, not just the sole jury instruction in isolation. The main problem that we're running into is whether viewed individually or as a set, this instruction risks jury confusion. It singles out the complainant's testimony. It implicates a different standard for other witnesses. It violates linguistic norms where we have a special rule for one category. Therefore, we imply that a different rule applies to the others. These last 3 issues regarding the confusion that might occur with a juror member are seen in some of the cases that we've cited in our brief, Luddy v. State, Stooks v. State, and Cly v. State.
But there are still a number of courts that approve a non-corroboration instruction.
Yes, Your Honor. And I think one of the cases that's cited most in my colleague's brief is the one coming out of California, and that's, I believe it's State v. Gamage. And what I think is important is when we look at some of the cases that the opposition has cited in justifying including this instruction, we're going to start to see some distinctions between the instruction that we're facing today and then the instruction that is used in those other cases. So just using Gamage as my first example, the instruction there is, it is not essential to a conviction of a charge of rape that the testimony of the witness with whom sexual intercourse is alleged to have been committed be corroborated by other evidence. Now, on the outset, I will admit that it does seem fairly similar to ours. I do think ours is a little bit more simple, but the reason why I think Gamage is so important for both sides is that it kind of provides this legislative intent and sort of the evolution of the non-corroboration jury instruction. So if we look at Gamage, which again, Your Honor, is a court that does find this instruction to be okay, they describe the historical context, and it's a 300-year history. There's the Lord Hail instruction. And I do think at the outset, a lot of these courts acknowledge the difficulty in proving or disproving rape allegations. And that's what originally led to instructions telling jurors to view victim testimony with suspicion. Now, in California in 1975, along with a lot of other jurisdictions, there was a shift in, I would say, the mindset regarding these sorts of crimes and the jury instructions that are typically associated with them. So in 1975, the suspicion-based instruction discontinued, and in the Gamage opinion, they're talking about why, and the court says it's outworn its usefulness, it performs no just function, and then there's this shift towards the single witness credibility instruction, and for the purposes of our case today, the non-corroboration instruction.
So hasn't society evolved since that historical explanation context that you have just described?
Yes, Your Honor, I would believe so, and and further in my argument, I start to try to use the Gamage words against itself. Gamage's justification for the non-corroboration instruction is it needs to remain because there's a continuing vitality in the sense that jurors needed guidance that no corroboration was legally required. I think another thing I need to say here is both sides, including the ones that we've cited in our brief, we're making huge assumptions about what jurors think and what they might not think. But when we have the non-corroboration instruction, we're assuming that when jurors walk into the courtroom, or excuse me, the deliberation room, at the back of their minds, they're thinking that, oh no, the victim needs to have their testimony corroborated. I don't think that's true. I don't think that's true anymore. Additionally,
But the converse, if the instruction is not given, would the jury then think that the defendant's the victim's testimony is and doesn't need to be corroborated? I mean, isn't the converse also that if the instruction is not given, the jury may think otherwise?
Your Honor, that might be the case, but what I'm trying to avoid here is saying nothing but negative things about this jury instruction. The simple fact is every corner I turn, I think I find another issue with this. So to answer your question, maybe the other issue that we're facing is the immediate instruction that these jurors received before the non-corroboration instruction talks about single witness testimony and how a single witness can prove any sort of fact towards the finding of guilt for the defendant. That alone already accomplishes what this non-corroboration instruction does. The only difference is it doesn't single out one witness and it applies evenly. The non-corroboration instruction opens up confusion. We go from single witness to the next instruction being when you listen to the victim, any of the testimony that they say, none of it need be corroborated. Again, another thing I should state, that is a correct statement of law. And I'm going to hope to get to this later on in my argument. That's not what we're arguing today. If I could go back to Gamage just a little bit, when they use the word continuing vitality, the Gamage opinion came out in 1992, and I want to make sure I'm not making the argument simply that, you know, if a case is 33 years old, any rules that it's come out with simply need to be disregarded because of its age. That is not what I'm trying to say. What I'm trying to say is in 1992, the California Supreme Court chose to use the language of continuing vitality as a justification to continue using this instruction. What I hear when I read continuing vitality is not perpetual vitality. I read that opinion to be on shaky foundation, and I do believe that time or the tide has changed in regards to victims and defendants in the context of criminal sexual assault cases. If the rule corrected an imbalance, which is what the Gamage court was pointing to, but that imbalance no longer exists, then the instruction risks becoming not a correction, but a new imbalance. And that's exactly at the heart of what we're saying today. The defendant in criminal sexual conduct cases, in my opinion, is already facing an uphill battle. By the time we go through jury instructions and this one's read, it seems to me that this burden has completely shifted from the prosecution into the defendant.
But doesn't it just really come down to whether the witness is credible?
I believe so,
In the
Your Honor.
jury's mind, does this affect that determination of credibility?
I think the other jury instructions go to the point of your question, Your Honor. The problem is after they get all these other jury instructions and we have one that sets one apart, are the jurors going to be confused? Should they accept everything that the victim is saying is true? I should also state that in this case, we did not have the jurors question this instruction with I guess like a document to the judge asking for clarification, but it has happened with a similar instruction. State v. Stooks out of South Carolina. When we're talking about juror confusion, I do believe precedent suggests a real risk in using these sorts of instructions, Your Honor. Did the instruction create a serious risk here? That isn't reflected in the record, but again, precedent shows it has happened. In State v. Stooks, the jury instruction read to those members were, there is no requirement that the testimony of a complainant of sexual assault be corroborated. This is nearly the same as ours. The jury in Stooks literally asked the court, or excuse me, the judge, if the instruction meant that they had to believe the victim. Now, the judge, in trying to clarify that confusion, didn't address the instruction as read, but he does reread the standard credibility instructions. Afterwards, the jury in that case returned a quick guilty verdict. The Supreme Court of South Carolina received this case and overturned the conviction because they felt that the instruction unfairly highlighted victim testimony, risked misleading jurors into believing they had to accept the testimony as true, and it effectively commented on the weight of the evidence. Now, just to make a strong point about this Stooks case, it overruled a prior 2006 decision in South Carolina, which had upheld the instruction based on legislative intent. I think one of the...
Does it make a difference in, in Stooks, of course, the jury submitted the question to the trial court asking whether the instruction had to imply that the victim's testimony must be accepted to be true. And there was also a separate constitutional provision that stated that judges can't charge juries in respect to matters of fact, but declare the law. And, here the argument is that the instruction wasn't judicial commentary, and the jury was also instructed not to interpret any statement or action by the judge as a comment on evidence. So doesn't that sort of distinguish Stooks?
Yes, it does, Your Honor. The thing I would counter argue to that point, though, is when we look at the variety of different cases cited by both sides, each case analyzes this issue from a different standpoint. So in Stooks, they have the constitutional legislation regarding jury instructions. They also have the incident of the jurors asking the trial judge for clarification. In all the other cases that we've cited, I don't believe that's the same issue. In Gamage, the jury's not confused. In Welch, out of the District Court of Guam, I don't believe the jury's confused per se in the sense that they're asking the judge. I do not think that would be a hindrance to this court addressing that sort of question, because at the end of the day, our main argument is the instructions really just gotta go. It's unbelievably confusing. I think another key question is, at what point does an instruction designed to counter unfair skepticism tip the scales too far? The record shows in this case discussions during voir dire regarding the burden a defendant in a CSC case faces just in having been brought to trial. I believe that the government's argument is to freeze Gamage in time. One of the reasons that they state that the instruction isn't misleading is when we look at the historical context and the instructions as a whole. But when we look at the historical context using Gamage, I believe Gamage assumes the 1970s and the 1990s concerns still exist unchanged. But to go to your point, Justice Carbolito, the reality is that law and society evolves, which is exactly why they made the change in the 1970s. The vitality of an instruction must be assessed in the present day context, not preserved indefinitely. in essence, what we like to argue is that using the words from that Gamage opinion or from that 1975 California case cited in the Gamage opinion, this instruction has outworn its usefulness and performs no just function. Excuse me.
So if I could just address some of those comments. I mean, when we look at what the trial court, as you've pointed out, but I just wanted to go through that analysis. The trial court emphasized that the jury should consider the instructions as a whole, and as you stated, it accurately restates Guam law. The majority of jurisdictions still provide or give this jury instructions, not necessarily that, that's what we should necessarily do. And here again, as was pointed out, the jury was repeatedly informed that they were sole judges of the witness credibility and the weight of the testimony. These are the other instructions that you pointed out, those that they justify it not being given. But if we're looking at the jury instructions as a whole, the court reiterated that the jurors were the sole judges of the credibility of the witnesses, and the weight in their testimony deserves just two sentences. Two sentences after delivering the non-corroboration instruction, that the jury was told that they may disbelieve all or any part of the witness's testimony. The trial court extensively addressed factors that the jury may consider when considering witnesses' credibility and the weight of the testimony. And included encouraging the jury to consider the reasonableness of the witness testimony in light of all the evidence in the case, as well as whether the testimony was contradicted or supported. And so in your argument, it is that this instruction just highlights the victim's testimony. I think may not totally paint the complete picture, that there are other instructions that seem to neutralize that it is just focus on the victim's testimony, that it need not be corroborated. And the majority of jurisdictions, when they look at the jury instructions as a whole, they seem to continue to support that it does not unduly it doesn't unduly focus on just the victim's testimony, and that is solely what the jury is concentrating on. And so I'm just saying that while you do point out that there are other instructions, I think the litany of the instructions, when you just sit back and look at it in the context of considering the jury instructions as a whole, doesn't unduly focus on this non-corroboration jury instruction as you are pointing out.
I think one of the things I find most interesting when courts are viewing the instructions as a whole is it almost appears as if, maybe I'm being a little bit too optimistic here, but it's almost as if we're assuming for a second that instruction 4E is improper. So can we justify it within the context of everything? Do these other jury instructions, I guess, remedy any sort of negative effects by including instruction 4E? But one of the things I'm thinking is that any sort of juror confusion may be a result of stacking instructions. What I mean by that is the reality is that jurors don't analyze instructions like lawyers. So instead of entirely balancing out problematic instructions, I think they might stack them cumulatively. So when they hear the single witness instruction and then immediately after the no corroboration rule, with its mention of only the victim, the instructions don't mitigate the no corroboration rule, they reinforce it. I think it entitles the victim to a heightened standard. I think it elevates the victim's testimony over that of any other party in the trial. And I know the defendant here didn't testify, but had they testified, would the victim's testimony be elevated simply because there's a specific rule calling out the victim? There's no rule calling out the defendant, the victim's family members, the police officers. It's solely just the victim. So maybe in the context of all the instructions as a whole, courts are looking at ways to remedy any sort of damage caused by the non-corroboration instruction. But I also think courts need to consider the opposite effect of what if all the instructions just reinforce the victim testimony? I also think that the issue with cases that uphold these instructions is that courts assume jurors weigh instructions to offset any problematic one. But if jurors were to misapply the instruction or confuse the instruction's purpose, or this sort of stacking that I'm referring to, I don't think the harm's neutralized, it's just compounded.
I think you should move to your next document.
Yes, Your Honor.
You only have 10 minutes.
Yes, Your Honor. If I could just close out this instruction, Your Honor, the instruction is, this issue, the instruction is a correct statement of law, but that's not the issue. We're not arguing that the instruction is legally inaccurate. The problem is the statute is relevant to the court. It's not relevant to the jury. This was not mentioned in either brief, so I'll just preface that. I think there's no better example of this than using the court's prior opinion in People v. Flores from 2004. Their defense argued that a lack of corroborative evidence justified finding insufficient evidence. The court rejected that claim because of the statute, but emphasized there was a corroboration in that case. That's exactly what I believe this statute is meant for. The second issue I'd like to discuss today, Your Honors, is the trial court erring and applying an incorrect standard in determining whether a new trial was warranted under 8 GCA section 110.30. I'd like to start this argument by stating Mr. Simmons is entitled to a fair trial, not a perfect one, but we aren't asking for perfection. At the outset, we have not waived this issue. The government cited to Lamb v. Hoffman for this claim, but the relevant paragraph right before the section that they quoted reads that the parties must articulate their arguments in a way that allows the court to apply recognized rules of law. Our brief states the issue, argues the standard of review, includes the applicable statute. The government uses their brief to discuss McDonough, and then we use our reply brief to go more in depth on the issues. So that's why I do not believe we've waived it here today. We do not believe McDonough should apply, not in cases like this. The McDonough case was a trial court that applied a standard from a civil case. McDonough stems from FRCP 59, which governs new trial standards in civil cases. And that language is not similar to FRCP 33, let alone section 110.30. I will admit that the government's argument that section 110.30 acting procedurally or acting as a vehicle is a strong argument. But if section 110.30 was only meant as a vehicle for constitutional violations, it would likely say so explicitly. And I do believe that language matters. The statute states a trial court may grant a new trial if required in the interest of justice. This broad language appears to go far beyond the bounds of what's contained in FRCP 59, which requires a new trial only for reasons recognized in federal court. McDonough is too restrictive for this case. It sets a high bar for new trials based on juror misconduct, which is an even higher bar than this court's admittance in other cases regarding section 110.30's. In our reply brief, the Guam cases provide a better standard. We use two, Guam v. Castro and Guam v. Kanata. In Guam v. Castro, there's a broader discretion in ordering a new trial. The court there discusses a reasonable possibility standard that if extraneous information could have affected the verdict, a new trial is warranted. Now, here the facts compared to Castro are different, Your Honors. In Castro, the juror sent a letter post-verdict that mentioned facts not in evidence. The court ruled the juror had extraneous information, and that created a colorable showing of misconduct. But why this matters here is that juror 12 had outside knowledge of a key witness, and that directly affects credibility assessments, making Castro and Kanata a more appropriate standard. In our case, the juror knew the key witness on a personal level. If I could talk a little bit about jurors 12's connection to the case itself, and I'm not trying to relitigate the facts here because the facts aren't at issue. We cannot argue that the juror lied during voir dire. We think it was an unintentional mistruth. The record does show that they disclosed prior jury service, so I don't believe that they lied intentionally here. But the juror did admit to knowing the witness and recognizing her when she took the stand. If you review the record, it appears that the witness in this case and the juror in this case only attended a couple of family functions. But what I think strikes at the heart of our argument isn't necessarily the family functions that are occurring outside of work. It's simply the relationship at work. These are two individuals who work together in a small section at a bank for several years together. They sat next to each other. They were very familiar with each other. And given the nature of the work, the juror testified that she would find the witnesses trustworthy. There's also juror obligations that I think go to the heart of our argument. The trial court emphasizes juror obligations at the end of each day. No media exposure, no discussions, no research. The jurors must report any infractions that they think they're seeing. The jurors are also reminded of jury instruction 2A, which reminds them that their voir dire answers remain binding throughout the trial. And here, despite recognizing the the witness on the stand, that juror decided to remain silent. The third issue I'd like to discuss, Your Honors, is that the trial court improperly admitted hearsay evidence. The government argues that the statements weren't hearsay because they explained how police began investigating this incident. And I believe that argument is flawed under existing Guam precedent. The problem we're running into is the record reflects that the officer already made it clear that he received a criminal sexual conduct report from dispatch. He's asked again by the trial attorney and confirms that when he met with the complainant, the nature of the call was the sexual assault. Why this is improper is the government is making attempts to ring the bell in that they appear to needlessly evoke the testimony that repeats the details of the witness's out-of-court allegations. Any officer could thereby introduce hearsay simply by saying, "This is why I pursued the case." The government argues that any error was harmless, but in cases like this, credibility is everything. When officers repeat complainants' allegations, it bolsters credibility in an improper way. If there are no further questions, I respectfully reserve the rest of my time.
On the issue of whether reversal is required under a harmless error analysis for the hearsay statements, if the out of court statements made by RSLD and RMDC were hearsay and the court abused its discretion in admitting it. There was other testimony of the victims. There were other, although there were inconsistencies between some of the testimony, the jury ultimately rejected the challenges to the credibility, and it appears there was sufficient evidence to support the elements of the crime. So why isn't that just harmless error?
Your Honor, if I could, I guess, clarify my last statement. When I was reading the briefs, it doesn't appear that the author is attempting to have Mr. Simmons' conviction reversed and remanded for a new trial solely on the issue of hearsay. It appears that we're addressing this hearsay issue as an attempt to get the prosecution to stop introducing it under the guise that they need to introduce it simply because we need to explain how the police officer decided to start investigating this
So
case.
it's a warning shot against the bow, so to speak, reminding them of our prior cases that this is inappropriate to try to bring this information.
I think that's a good way to characterize it, Your Honor.
Okay, thank you.
Thank you.
Thank you, Mr. Spitansky. Ms. Tenori?
My screen is not working, Your Honor, so I'll just be looking to the back of me. Mr. Chief Justice, and may it please the court. In this case, the appellant takes issue with the no corroboration jury instruction. And the no corroboration jury instruction is still used by majority of the jurisdictions across the nation. Here, the jury instruction is important, especially and not redundant in light of jury instruction 4D. Now, the appellant brings up that if the jurors are given a jury instruction that says that a single witness's testimony may prove a fact, then it was redundant, and therefore this is tipping the hat in the favor of the victim. However, if you view the language explicitly in 4D, it actually says, before you conclude that the testimony of one witness proves a fact, you should carefully review all the evidence. That last clause is why the no corroboration jury instruction is necessary, because the single witness jury instruction almost says, well, there should be other evidence, and the no corroboration jury instruction merely explains that there does not have to be more than the victim's testimony. In this case, there was a whole, as Justice Carballo points out, litany of jury instructions where the jurors were instructed that they are the sole finders of fact, and they are the sole judges of credibility, that nothing the judge said should be misconstrued to favor any one particular party, that they should be viewing the instructions as a whole, and that again, because they were instructed that they should not be singling out as a whole, I don't believe that the appellant's argument that it compounds the confusion is correct. This is also especially in light of, if you review the defense counsel's closing argument, they specifically reiterated there's no corroboration in this case. There's no corroboration in this case. So all that the victim need not be corroborated jury instruction does is, one, it accurately reflects the statement of the law here in this jurisdiction, and two, it curtails any argument by the defense that somehow the prosecution didn't meet its burden because there was no corroboration here. Now, this is reviewed under an abuse of discretion standard, not de novo. And the difference is because this court only reviews de novo if the instruction is a misstatement of the law. And as the appellant concedes, it's not a misstatement of the law. We review for abuse of discretion. And this court has repeatedly said in People v. Demapon and other cases that as long as the jury instruction tracks the language of the statute, then it is not error for the court to have instructed on it. And so even though the appellant makes the argument that somehow there should be a different standard of what the judge has to use as a law versus what a jury can consider, they've cited no authority for that. And I don't believe that that is even a correct statement of the law, because we have to give the jury and the jury this instruction. I want to talk about the assumptions that the appellant has brought up.
Go in, because I think that's an important point that you raised, that the defendant's closing arguments focus on the lack of corroborating evidence, and also that the absence of certain witnesses.
Right.
And that in reference to the thoroughness of the police investigation. So with that type of arguments, I mean, the trial judge, when the trial judge in exercising his discretion in giving this jury instruction, go to addressing those arguments?
Correct. And that is always why this jury instruction is included. And I believe that the trial court judge made the record that they have to give this instruction because it's the correct accurate statement of the law, and to also address any arguments that may be made in the defense closing arguments, which leads me to the other point that I want to make.
And if the defense counsel had not made these arguments and not commented on the lack of corroborating witnesses, the absence of certain witnesses, do you think that these instructions should just be given, this particular jury instruction, non-corroborating instruction, should just be given as a matter of course?
Yes, and that goes to my next point. The appellant talks a lot about gamage and how the government wants to freeze gamage in time. And I want to talk about the issue whether society has changed and with regard to whether a Lord Hill instruction should be given. Those are, while the appellant says these are all assumptions, they are not. And here's why. If you look at any transcript from any voir dire for any criminal sexual conduct case that particularly I have done. I'm not actually sure it was whether it was done in this case because the transcript wasn't ordered for this case for the jury selection. There is a question that is always posed to the jurors. Who here believes that the government should not be able to bring a criminal sexual conduct case if we did not have evidence other than a victim's testimony? Majority of the jurors on this island raise their hand. And so that's not based on assumption. That is based on record. If you go through these transcripts, these assumptions are still being held by the jurors, that they don't believe the law. They don't agree with the law. They do not agree, even though the Lord Hill instruction has been rescinded and the law has evolved, they don't agree with that. And they still believe, most jurors still believe that the victim's testimony should be corroborated. So as a matter of course, I think it is important to dispel any of that notion. And as a matter of course, it is necessary to weed out jurors in the jury selection process who believe they cannot comport with that law. So that is why this instruction is necessary. It's a correct statement of the law, and it does not give undue emphasis to the victim's testimony. The appellant brought up the issue of, well, there is no jury instruction for the defendant's testimony, so that should be taken into consideration. Well, one, that has already been rejected by the Ninth Circuit in People v. McGravy. They're saying the defendant, there's no need for a jury instruction regarding the defendant's testimony. And additionally, there is no need for that regarding the defendant's testimony because the prosecution is never allowed to allude to the defendant's right to remain silent. So any jury instruction that even talks about the testimony at all, that's already going to be error. So the only jury instructions we use ever for the defendant's testimony is he or she did or did not testify. You should treat this as any other witness. So in this case, he happened to not testify, and therefore that particular jury instruction, or the jury instruction was given, he didn't testify, treat this as you would any other witness, or do not let that fact enter into deliberations. So there is no undue emphasis on the victim's testimony here, especially if the trial court repeatedly instructs the jurors that they are the sole credibility of the witness, and at the end of the day, it is up to them. Especially in this case, there was no abuse of discretion because there were two victims. So it wasn't a case where it's you have one victim with absolutely no corroborating evidence. It's you have two different children at two separate times disclosing that they are abused by the same defendant. And so in that case, I actually think that the appellant's argument is diminished because of the presence of the two victims here. And again, just to say about the history and evolving and how history is evolving, in the case law that I have set out in my brief, up to the year 2022, 2020, 2005, the courts are still upholding this jury instruction. So it's not something that is frozen in time. They are considering the modern day need for this jury instruction, and that it still remains the standard that victim testimony need not be corroborated. The case is cited by the appellant regarding the impropriety of this jury instruction. It really, it is based on two arguments: that it places undue emphasis on the victim's testimony, which I already covered. The other one is that some courts have said it's a comment by the judge on the victim's testimony, but that cannot be true here if the judge repeatedly says, I don't have an opinion on this case. You are the sole triers of facts. So that will be that is your duty. And so all the jury instruction says is that you could convict based on the testimony alone, not that you should. And because that is a correct statement of law, the trial court did not abuse its discretion in instructing the jury as to that. Now, going to the defendant's motion for new trial, I believe that they did waive the issue, and here's why. Their opening brief only sets out the statute and has no legal applicability. There's no legal analysis as to how the court exactly erred in the decision and order granting a new trial. So what I had to do was kind of guess what their argument was and formulate my own argument. And that's why I believe that the issue is waived, because when the parties are left to guess what the argument was, then that should be issue for waiver. And if you look at even the number of pages they used on it, is a page of just the statute and the appellant saying it was wrong, and then they move on to the next issue.
But doesn't it concern you that a juror is, I think impliedly, has information about
So
some of the facts involved in the case?
So I will go directly to that point, Your Honor. Even using the McDonough standard, the trial court found that it did not violate the McDonough standard. And if you look at the record, I don't believe it did. And here's why. The juror in question, juror number 12, the only comments or testimony that she added to this whole trial is, these are my granddaughters and they slept on the futon in the living room. That was the extent of her testimony. And so I believe it would be different if she was the victim and the juror number 12 had, if the grandmother was the victim, I think it would be a different story. But here, because she was not the recipient witness and that she is the one that was victimized, I don't think that it's concerning, especially because even if you think about the rules on Guam, whether, when judges have to recuse their case for appearance of impropriety or things like that, that even applying that standard, she would not have been excused, because here she didn't know the victims. Juror number 12, it made clear she actually never met the children. And I think that is the deal breaker when it comes to whether or not she had actual bias. She didn't know the children, and she actually was not dishonest during the voir dire. Those are things that the trial court found in the evidentiary hearing. Because what had happened is, it's important to review the way the trial courts ask the question during jury selection. And the question is always this: who here knows any of the witnesses, and can you still be fair and impartial?
But I think part of the argument, you're addressing the issue of the actual bias. And Mr. Spitansky is, as I understand, based on the relationship, just the co-worker proximity, they're in a very confined place, and there seems to be maybe a sense of trust and friendship, that there may be an implied bias here by just reference
So
because of their relationship.
in reviewing the law on this, so the circuits or the courts are split on this, but under the second prong, they have to prove actual bias, and implied bias is only found in exceptional circumstances. I do not believe this meets the exceptional circumstances. Even if they were coworkers, it was not during the time that these acts were occurring.
What would be your example of an exceptional circumstance?
If someone themselves was a victim of a crime, a criminal sexual conduct crime. And so that's why it brings me to the point where they would have to show that the challenge would be valid for cause. So if someone did not divulge that they were a victim of criminal sexual conduct, I do believe that would be an exceptional circumstance warranting review of that issue. But in this case, these were not people related by blood or affinity to the fourth degree. They were coworkers. She had never met, juror number 12 had never met those victims. She may have met the mother, but in the end of the day, the mother was testifying for the defense anyway. She was on the defendant's side. And again, even if there was only one comment during the evidentiary hearing that she made regarding her perception that the grandmother was trustworthy, but it was based on a leading question by the defense attorney. The defense attorney says, well, something to the effect of, well, do you think that she's trustworthy because Code 360 would not hire an untrustworthy person? Then she says, yes. I don't think that is a like a finite enough answer for us to say she has an implied bias. And that juror had repeatedly said, I did not alert anyone to the fact that I knew her, I recognized her because I knew I could be fair and impartial. And I believe that that doesn't rise to the level of implied bias, again, if she didn't know the victims and she had no knowledge of the facts of the case. So it would also be different, to go to your Honor's earlier question, if she had visited the house and had personal knowledge that the kids were all sleeping on a futon in the bedroom, because that was the testimony that the grandmother offered, but she doesn't have that knowledge. So under the McDonough test, which is the appropriate test, the defense that wouldn't be a valid challenge for cause. And they would have to prove that there was a valid challenge for cause, which the trial court said, no, there's not. Because as long as people are saying they're fair and impartial, and the relationship is not one where you would question that impartiality, then that decision should stand in that case. And it's puzzling to me. I want to go back to why I think I argued waiver. Right now, on appeal, the defense is arguing that McDonough is not the correct standard, but they brought the motion for a new trial based on McDonough. So that's why I'm not really sure what their argument is. My argument is this. The rule, HGCA 110.30 is merely the mode in which you bring a motion for a new trial. There is no standard given under that statute. And the courts have reiterated this. Castro and Canata, that the appellant brings up, that is not distinguishable, because that's if jurors are discussing extraneous information that could influence the verdict. There is no allegation here that the grandmother even told the other jurors, hey, I know this lady from work. So that is a different standard, and that's a whole different standard when you're trying to think about whether it influenced the verdict. Here in this case, there is no standard, so you have to go to Federal Rule of Criminal Procedure 33. Now, even though McDonough wasn't based on Federal Rule of Criminal Procedure 33, it is based on Sixth Amendment constitutional violations. And the Ninth Circuit has repeatedly said McDonough is the standard for both criminal and civil cases. So they don't believe it applies because it's a civil context, but that is the standard that Ninth Circuit is using for criminal cases and other jurisdictions are using. So here in this case, the trial court is given deference when you review a motion for new trial, because the trial court is the one that's observing the demeanor of the jurors, if their answers are honest, both in the jury selection process and then also the evidentiary hearing that occurred after. And so in this case, the trial court was given deference. Even at the evidentiary hearing, the juror number 12 repeatedly said she was still fair and impartial, and it did not enter her deliberations. And so there, it was not an abuse of discretion for the trial court to deny the motion for new trial. And there is case law that says the mere inability to use your peremptory challenge is not going to rise to a McDonough claim. So I think that's essentially their argument on appeal is, well, if I had known this, I would have used a peremptory challenge on this because it did not sit well with me. But that's not the standard. So while I think it is, of course, at first blush concerning that she may have known her, when you ferret out the testimony by that juror, there is no cause for concern if she's still saying that she was fair and impartial and that the McDonough test, a challenge for cause would have failed. Now, for the third issue, which is the testimony by Officer Cruz. So here, the testimony by Officer Cruz, there are two statements in question. One, that Officer Cruz says, well, the mother told me that one of the victims said she was sexually assaulted. That is all that was elicited from that officer with regard to RSLD. Now, that is not an out-of-court statement made for the truth of the matter asserted. That is effect on the hearer under People v. Roten. It is notable here that he didn't say the details of the sexual assault or that RSLD. We don't even know by his statement what even that means. She was sexually assaulted. That statement alone would not rise to the level of a conviction for Mr. Simmons. So So that could not have harmed him. And so under a harmless error standard, because they did object to that particular statement, reversal is not required because we garnered nothing from that statement, but the complaint was a sexual assault. And so while Mr. Spitansky is saying that, well, we're warning the government that they can't be doing this, the government is allowed to establish that a complaint existed. We know we're not allowed to establish the details of the complaint, but the reason for bringing out that statement was because they were trying to establish a timeline of who told who what, which is Officer Cruz arrived at the house and the complaining person, the mother, says, my daughter told me this is why I'm here. That's it. No other details of it were elicited. The second statement is by RMSD to Officer Cruz that she was assaulted. So again, even that, it doesn't even have, even that statement does not have enough details to rise to the level of convicting Mr. Simmons. So it's not made for the truth of the matter asserted if we know that it's even insufficient to convict him of just that one statement. And they did not object to this particular statement, so that is reviewed for plain error. And again, there were no details elicited by the statement. The reason why that statement was elicited was because that was the first time Officer Cruz's interaction with RMSD is the first time anyone knew that RMSD even had allegations. So really the eliciting of the two statements that I was there for a complaint, one of the kids was sexually assaulted, one that the other kid was assaulted, it was to establish a timeline. So it didn't have details in it to be made for the truth of the matter asserted. That's not what that was used for. And at the end of the day, even if it was, had the fact that there was a sexual assault complaint, that was cumulative anyway, because the whole trial was about the two victims coming forward and saying how in fact they were sexually assaulted or how they were assaulted. So for those two, for one, for the first statement, there was no abuse of discretion in letting that in. For the second statement, the court did not plainly err also on letting that in as well. I just want to talk about the standard of review for the no corroboration jury instruction so I can ferret out what, actually I did. Just to reiterate, this is abuse of discretion, not de novo, because they are conceding that it is a correct statement of the law. And then for when you review even their cases, Stukes and Ludi, all of those courts are all judging the jury instruction by harmless error standard. So it's even different than what we would do here. I mean, it's harmless error if we get to the court abused the discretion, but if it did, was it harmless error, then you get there. But I'm just pointing out that that is the correct standard of review to apply for that issue. And then I believe that the standard review we already discussed for the new trial, that is abuse of discretion. You don't get to a de novo standard review unless they're actually attacking the finding of the actual applied bias, but there was no analysis on that. So there was no abuse of discretion. And then I already covered the standard of review for the third issue. So if there are no further questions, that is all I have.
If you go back to the argument that I think it was the prior jury instruction about you make a decision about truthfulness.
Mhm.
And then the next is corroboration. Doesn't the corroboration go more to the burden of proof than whether the victim is truthful or not? Because it's a way of saying the government meets its burden if you believe the victim's testimony.
So I don't think that the no corroboration jury instruction alludes to the burden of proof, because here when it goes to legal sufficiency, but not the burden of proof of beyond a reasonable doubt. So the no corroboration jury instruction is not, again, telling the jurors that they should in fact convict because the government has met this burden of proof. It is saying that it is legally sufficient if you believe the victim, based on the credibility jury instruction, it is legally sufficient if you believe the victim to find them guilty without there being any corroborating evidence like DNA, because that's actually what the all jurors want, right? Is DNA, some type of rape kit or medical exam. So that is what that is talking about, merely the legal sufficiency and that the government is allowed to bring these cases. And again, that is to curtail any defense argument that somehow they convert it into burden of proof at the end. That's the issue, is defense converts that to, if that instruction weren't there, they convert it to, well, the people did not meet their burden of proof because that was legally insufficient evidence anyway. So they kind of conflate the two, which is why it's really problematic. And we just have to remind the jurors that there does not necessarily have to be corroborating evidence like DNA or a rape exam. Thank you, Your Honors.
All right. And thank you, Ms. Tenorio. Court has no further questions. Mr. Spatansky, you have 4.5 minutes. Excuse me, it was 3 minutes. I'm sorry.
Thank you, Chief Justice. I'll address the no corroboration instruction again. Your Honors, I think when we're looking at the cases that have upheld this instruction, we really need to look at the language of the instruction because that matters. What makes this case different from others cited by both parties is the specific wording of our instruction. It's very plain, it's brief, it's blunt. If we look at some of the cases cited by my colleague Price and Barnes out of the state of Mississippi, they both had different instructions. But my point in bringing up those cases is that they both included clauses to remind the jurors when you're listening to the victim, if you're going to believe them, you still need to believe them beyond a reasonable doubt. You see this reflected in the District Court of Guam cases from the 90s. That's Welch and McGravy. Both cases derive their instruction from the same statute that we're talking about today, yet they included the clause about reminding jurors that they need to find the victim's testimony credible beyond a reasonable doubt.
Aren't those other parts of that instruction also exists in the other jury instructions? It's just that it may not be consolidated in the one jury instruction.
They do, Your Honor, and maybe that goes to the point of why this instruction is so improper, is that they just simply remove it. You go from sheet to sheet looking at these jury instructions, and sure, maybe just for example, jury instruction 1C might have the reasonable, the credible beyond a reasonable doubt standard. But when they get to the one talking about the victim testimony, it doesn't include any of those clauses. And I think that's damaging. The other point I would like to make about this instruction is one that my colleague just brought up. It's this idea that we need to include this instruction to curtail defense's argument. If you review the record when there was an objection raised for the instruction, the court says, no, we're still gonna, I'm paraphrasing, the court says, we're still gonna include the instruction because it nonetheless doesn't prevent you from arguing a lack of corroboration at closing. The problem is we can get up, do a 1 hour long closing talking about no corroboration. The fact of the matter is we're going to give the jurors an instruction saying that that's essentially irrelevant. The Gamage opinion has a concurrence in the Gamage opinion does reflect this. And
But your argument also is the jury pays very close attention to those instructions. So you're saying that only specific instructions.
No, Your Honor, I believe that they pay attention to all the instructions. Our concern really is when they get to the victim testimony, if they're going to be providing it too much weight, going back to the stacking issue. I think one of the concerns that Justice Kennard in his concurrence in Gamage talked about is this, he's referring to the majority opinion. There's a necessity to strike a balance and protect rights. That opinion prefaces its discussion regarding the necessity in striking a balance by acknowledging the prosecution's burden, saying it places a heavy burden on the complainant without corroboration. Now, I want to be sure to say that the government isn't necessarily arguing this. Instead, they're arguing that the instruction is important to counteract a defense argument regarding absence of corroboration. The concurrence reminds us, however, that trial courts should give jury instructions to inform jurors of the law, not to create a proper mix of pro-prosecution or pro-defense instructions.
And it accurately states the law.
It does accurately state the law, Your Honor, but nonetheless, our position is that is a matter for trial courts and for this appellate court, not for jurors.
All right, thank you, Mr. Spitansky.
Thank you, Your Honor.
Mr. Mario. The court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.
All right.